of hands sadly passed over the weekend. Professor Haynes was quite instrumental in a lot of the human rights narrative through a lot of work we had done in the community. In fact, in the book about his loss, now condolences are extended to his family and friends and loved ones. Of course, the friends and people were at the Center for Human Rights was quite enriching and engaging. We had we were to be doing justice and over the proceedings yesterday. We had our chairperson, Professor Mola, as well as public advocate, and discussions on human rights. We, human rights, noting the number of complaints that we've been receiving, the interest in this matter, and of course, what's been happening at a very high level in our political structures. Note the need for this to be a discussion which is frank and open today, and rather over the next 3 days, which in time we anticipate. I've just been informed that there might be some connectivity issues, so I do advise if there is a break, I'll pause for a second, hoping that it's not on my end. But to continue, if there are any technical issues, please just drop me a message. This is the nature of working on the remote participation and via virtual platforms. I'm getting a notification that there's some issues with the connection. If you could bear with me for a second, we check. Okay. Just to further announce, and I'm hoping that it's going to be in order now. Following yesterday's proceedings that we had, in fact, moving on to day 2 today, and over the next 3 days, we're looking at the human rights-based approach to corruption as well. It's just a conversation starter, at least on the side of the Human Rights Commission. There will be more endeavor down the line. We'll be looking at specific issues with this category and this theme. So it's to get the conversation going. At the same time, we are very grateful to our sister organization, the Office of the Public Protector, for collaborating on this project. Of course, we look forward to many more engagements of this nature down the line. In terms of the proceedings for today, and I must note that there was a change in the program yesterday. We were ready to have Mr. Tabiso Lu, who joined us yesterday, who I think are quite familiar with him and needs no introduction in terms of lifting the lid and being a whistleblower unrealized because of these corrupt practices that have been placed. I won't go into the details of that. It is available on our YouTube if you wish to play back yesterday's proceedings. We were also joined yesterday by Dr. Oral. We were due to be joined, there was change in program, but so due to the shift around, we will today be joined by
Please unmute.
Oh my gosh. I think I was muted there. I didn't press anything. I've just handed the floor to Mr. Jan van Schalkwyk to do the presentation on behalf of the Auditor General. Thank you.
Fadla, I just noted a message in the chat from Mr. van Schalkwyk that he's having audio connection challenges. Maybe perhaps we can move to the next item while IT is trying to resolve that on his side.
Noted. Mr. Seseko from the Independent Police Investigative Directorate, IPID, are you ready? If you could take the floor, and then immediately thereafter we can pass over to Mr. van Schalkwyk. Thank you.
Good morning, all. Yes, I'm ready.
Thank you, Mr. Seseko. You may proceed.
Thank you. I've sent the presentation yesterday. I think it can be put. Thank you. So, colleagues, my presentation will talk to the IPID mandate, workload on corruption matters, investigations of corruption matters, and investigation challenges. Can you move to slide 3, please? As some of you may be aware, the mandate of IPID is to conduct an independent and impartial investigation of specialized criminality committed by members of the South African Police Services and the municipal police. The mandate focuses on specified identified offenses as per Section 28 of the IPID Act, which was signed into law by President Jacob Zuma on the 12th of May 2011. And the minister also signed the regulations into operation on the 10th of February 2012, the IPID regulations. The matters, the kind of matters that IPID investigate in terms of Section 28 are specified as any death in police custody, death as a result of police action, any complaint relating to a discharge of an official firearm by any police official, rape by a police officer, whether the police officer is on or off duty, rape of any person while that person is in police custody, any complaint of torture or assault against a police officer in the execution of his or her duties. We investigate corruption matters within the police initiated by the executive director on his or her own, or after receipt of a complaint from a member of the public, or referred to by the directorate by the minister, an MEC, or a secretary of the police, as the case may be, and any other matter referred to it as a result of the decision by the executive director, or if so requested by the minister, MEC, or the secretary of the police. And then in terms of Section 28(2), IPID may investigate systemic corruption within the police. So this is the general mandate of IPID as specified in Section 28 of IPID Act. In terms of Section 29 of the IPID Act, provides for the reporting obligations and cooperation by members of the SAPS, and those that, please move to the next slide. And those that must report is the station commander, any member of the SAPS, and any member of MPS. So unlike the predecessor to IPID, which was ICD, now there's an obligation on the police to report all matters that fall within that section 28 to IPID. So these matters that where there's an obligation on the police to report to IPID is death in police custody, death as a result of police action, any complaint relating to a discharge of an official firearm, rape by a police officer, whether on or off duty, rape of any person in police custody, any complaint of torture or assault against the police in the execution of their duties. Failure to comply with these reporting obligations in terms of Section 29 of the IPID Act constitute a criminal offense in terms of Section 30. So if the police fail to report, then we can lay a criminal charge against them and prosecute them in terms of Section 33 of the IPID Act. This just gives you an overview of the matters of corruption that are received by IPID. I flag here the corruption matters intake for 2019-20 in terms of provinces, and the ones received from MPS, from SAPS as well as MPS. You will note that 2019-2020 we received a total of 84 cases, Gauteng having the highest number of cases received, with 21 cases from SAPS and 8 cases from the Metro Police. Gauteng is followed by NSID. NSID is a National Special Investigative Task Team, which operates from the national office. This unit investigates all high-profile investigations you may be aware of, most of which were on the media, where we arrested a number of generals for involvement in corruption and money laundering. So you'll note from this slide that in 2019-20, 75 cases were received from SAPS or were investigated against SAPS members, and then 9 against MPS members. The next slide shows the comparison between 2018 and 2019. You'll note that in 2018, 2019, and 2019, 2020, there's a difference of 24 cases, which is less. So we had more cases in 2018, 2019, with Gauteng still the highest, followed by KZN. So there's a difference there of 24. So in 2018, 2019, there's been a decline in the number of cases that we've investigated against members of the police and MPS. As indicated above, SAPS has an obligation to report to IPID on all matters referred to in Section 28(1) A to F in terms of Section 29. However, there is no reporting obligation in terms of Section 28(1) and 28(2). So 28(1) is corruption matters, and 28(2) is systemic corruption. So in relation to these matters, there is, in terms of the Act, there is no reporting obligation by the police. Most of IPID's corruption matters are brought to IPID's attention through walk-in complaints and whistleblowers. IPID deals with all forms of corruption cases brought to its attention, from a 100 Rand Metro Police bribe to a multi-million Rand procurement fraud cases within the SAPS. IPID is dealing with a number of high-profile cases involving police generals at present, some of which have been reported in the media. Some of these matters are already before court. IPID has recently signed an MOU with the investigating directorate, the ID within NPA, which has taken over a number of these high-profile corruption cases as part of the Fusion Center investigation. ID has, in addition, IPID has, in addition, seconded IPID investigators to continue to investigate the cases which were previously investigated by IPID, but now have been dealt with by ID. IPID, whilst doing its best, the best it can with the limited resources it has to deal with this investigation, also face a number of challenges while dealing with corruption cases. These include limited resources in terms of budget and human resource, challenge in obtaining information, crime intelligence, declassifying documents required. The matter is reported in the media. IPID challenged SAPS and was awarded judgment to the effect that in the interest of justice, IPID should have access to these documents. SAPS has challenged the ruling, but the appeal has been dismissed. So on this issue, we've had a lot of challenges in terms of getting classified documents from SAPS in mostly corruption investigations that we are conducting against members of the SAPS, especially in the crime intelligence environment. And this resulted in litigation between SAPS and IPID. And IPID has won this litigation. And the judgment basically now forced SAPS to comply with Section 29 of IPID Act, that they must declassify and provide all documents that IPID requires to enable IPID to conduct investigation. The SAPS appealed the decision. They lost that appeal. I've seen media reports. We have not got confirmation from SAPS. We have not received papers from SAPS, but we've seen media reports that SAPS is considering and petitioning the Supreme Court of Appeals. We have not seen that, but we'll deal with it as it comes. One of the challenges that we've experienced as IPID is counter-investigation by SAPS members, especially in relation to these corruption matters. So they would investigate or open cases against IPID investigators to counter our investigation and approached witnesses in the investigations that we're conducting. We also approached the court in this regard, and we also got judgment in our favor to stop SAPS members that were investigating, to stop investigating IPID or to counter our investigation. The other issue is the complexity of some types of the corruption matters, especially corruption, procurement fraud and corruption that need specialized skill like forensic investigators, which capacity we don't have in IPID. MOU between SAPS and IPID on cooperation regarding joint operation and sharing of resources is yet to be signed. We're waiting on the SAPS on this one because of the issues we've raised of limited resources. We have engaged SAPS that we need to share some of the resources so that we are assisted in this regard. As there's no obligation on SAPS and NPS to report corruption-related matters, the extent of corruption within SAPS and SAPS is still unknown. We are, however, in the process of reviewing the IPID Act. The amendment process is underway, and as part of the review, we want to have this as part of the reporting obligation on the corruption matters. The extent to which this will increase IPID workload is unknown, and IPID will, with IPID already having severe human resource, budget, and technology constraint, adding this to IPID mandate may create an environment where IPID will be completely overwhelmed with cases without the ability or capacity to adequately attend to them. Thank you, colleagues. That is my presentation, and I'll be able to take questions if there are any. Thanks.
Thank you so much, Mr. from the Independent Police Investigations Directorate. Thank you for your presentation. I am informed that there might still be some technical issues with Mr. Van Schalkwyk. I'm not sure if anyone can confirm if he is ready to be connected or if we should shift the program around a bit. Whilst our IT guys are, okay, I see Mr. Van Schalkwyk is possibly.
I may have sound at least.
There we go. Perfect. Thank you, Mr. Van Schalkwyk, for your indulgence and to our viewers as well. So you have the floor and you may proceed. Thank you so much.
Thank you very much, and good morning to everybody on this webinar. I apologize for our side of the technical glitches that was there. I'm very glad that we can in fact make this work. I think the sound is working at this point in time. I don't think the camera is working, but let's make the best of it. Thanks for the opportunity of joining me on something so important. It's wonderful to see such participation on a topic that this important. Corruption and human rights are often viewed as not interrelated, but we're very clear in our minds that that corruption definitely impact on human rights. Corruption, maladministration, malfeasance, and public administration ultimately deny citizens the services that are, in most societies, considered to be human rights. If we think about the United Nations that in 2015 adopted the Sustainable Development Goals as part of the 2030 Agenda for Sustainable Development, and that becomes quite evident. The 17 SDGs are built on the Millennium Development Goals and aim to improve equity and justice across the globe by guiding countries in their efforts to end poverty, to protect the planet, and to ensure that all people enjoy peace and prosperity. At the core of the SDG agenda is giving citizens around the world access to public services, which broadly refers to services provided by governments, state-owned entities, and entrusted private entities, such as civil society, all to benefit the citizen. South Africa is a democratic state founded on 4 constitutional values, the first of which is human dignity, the achievement of equality and advancement of human rights and freedoms. The Bill of Rights in Chapter 2 of the South African Constitution forms the cornerstone of our country's democracy and gives effect to the democratic values of human dignity, equality, and freedom. Several of these basic human rights, including the right to education, housing, health, food, water, and the list goes on, tie back either directly or indirectly to the state's obligation to deliver services to its people. Transparency International briefly defines corruption as the abuse of entrusted power for private gain, and certain forms of corruption in service delivery, such as nepotism, bribery, undermine the human right of equal access to public services. Corruption also exacerbates fundamental inequalities in citizens' access to the guaranteed right to services, as the most marginalized population segments are always the most effective. One can summarize this as follows. The inability or unwillingness to curb corruption can therefore be seen as a failure by states to adequately provide for human rights by depriving citizens access to public services. This creates a greater divide and inequality in society as the wealthy can afford private services. There is therefore a compelling argument to consider the fight against corruption in service delivery as an absolute integral part of the human rights-based approach to development. Let me move closer to where we find ourselves as the AGSA. Over many years, the AG has raised serious concerns about the pervasive culture of accountability failures, lack of strong internal controls and delivery of services, and ineffective management of state resources. These are sentiments that's very clearly shared by oversight structures, the executive, civil society, and the citizens. This then begs the question, who is responsible for the pervasive failure of accountability throughout the value chain? What role do we have to play as institutions established to support democracy? The core function and reason for the AG's existence is well articulated in Section 188 of the Constitution, further regulated by our Public Audit Act. The HSA, as the external auditor of government, plays a unique role in combating corruption. Considering the institution's ability to interrogate and guide on preventative control, it certainly contributes to the role of government and societal approach towards the fight of corruption. As a matter of course, our audit teams make recommendations about weaknesses or the complete absence of preventative controls. If these problems are not addressed appropriately and timeously, it could create fertile ground for corrupt practices to fester and contribute to the misappropriation or even the wasting of public funds. We also consider requests for special audits and investigations, a mechanism that reinforces our environmental scanning and creates valuable input into our normal audit risk assessment processes. In doing this, we are better able to understand the risks present at our auditees and adapt our strategies. In April 2019, and in response to a lot of these accountability failures across the value chain, the Auditor General was also mandated to raise material irregularities identified from the course of its audits. The aim of this extended mandate is to curb the loss of public funds and encourage accountability, honesty, integrity, and transparency within the public sector, and in particular, to hold accounting officers and accounting authorities to account. By definition, a material irregularity is non-compliance with or contravention of legislation, or any fraud, theft, breach of fiduciary duty identified during an audit, and that is likely to result in a material financial loss, the misuse or loss of a material public resource, or substantial harm to a public sector institution, or even the general public. Suspected material irregularities can be referred to appropriate public bodies for further investigation, but the Auditor General is empowered in most instances to make recommendations for the attention of accounting officers. Failure to implement these recommendations within a specific period can then lead to binding remedial action. Not implementing this remedial action may result in certificates of debt being issued in the personal capacity of the accounting officer or the members of accounting authorities. The process is meant to enhance accountability. It's not designed to, or let's say, the success criteria cannot be the certificate of debt, but the amount of instances where we've convinced accounting officers to do the right thing. We've made steady progress in implementing these extended powers across auditees and implementing the material irregularity definition. As part of the process of implementing this change in legislation, we've also embarked on a massive campaign across the country to encourage the restoration of accountability mechanisms. Let's move to the absolute current, as in tomorrow, where our Auditor General then will be tabling certain outcomes related to the last year's public finance management cycle. Perhaps just a little bit of context building up to that. At the moment, we're very active in the space of state-owned entities. These were areas that was traditionally not under the audit of the AG. We've taken back the majority of those. At the moment, we're busy with the Transnet audit take-back, and the next one that will come back into the portfolio would be the Eskom audit. You would have also seen a very different approach from the Auditor General's office in the recent proactive COVID-19 audits. You would have seen at least 2 special reports. And very soon, I suppose around about June, you'll see some municipal reflections on that as a special report 3. And you would see that there's a lot of things that we've done different there. The emphasis on preventative controls very early on, red flags around potential indicators of fraud. I won't bore you with some of the details, but I think one of the biggest things that we've learned throughout this process is the value of collaboration. The fact that we could take a lot of these red flags and findings to other colleagues, to other bodies, most prominently probably the sharing that we could do with the Fusion Center led to very proactive reaction. People that picked up on these failures and took action. I think you can just think about the SASA environment and the UIF environment in recent months to think about the success of that. In all our efforts, we must strive to achieve improved accountability and service delivery and ultimately to combat corruption in our society. The nation demands effective consequence management, and we will not hesitate to implement the instrument given to us in our enhanced mandate. And important with any credible partner in the fight against corruption. Later this week, I flagged it earlier, it's now tomorrow, the Auditor General will release our general report detailing our findings in the 2019-20 PFMA audits for national and provincial government. I urge you to engage with this report with specific emphasis on the section that deal with material irregularities and to be an active participant in the accountability value chain as well as the fight against corruption. The citizens of South Africa certainly deserve that. Thank you very much.
Mr. Van Schalkwyk, thank you so much for your contribution, and indeed forward that report tomorrow. And as you said, we encourage our viewers to engage that report and see what you found in terms of the and the government levels, local government levels as well. We were due to have a short for colleagues or the viewers second proceedings look specifically international and regional frameworks, the human-based approach in corruption. So permits the assistant IT if they has questions 7 minutes because and we will do at the liberty so that I put in the
There's a hand from the chair. But there's a chair from there's a hand from the chairperson of the commission. There's a hand from the chairperson of the commission.
For break discussion, I can please the break. It is now Zoom in speed and live. And this would you like people Professor
Well, thank you.
Speaking, you also indicating that you possibly. Okay, we can see you. You may proceed.
Yes,
I
was saying,
can assist, Chair, our team.
Can I speak now? Hello?
We can hear you, Chair.
We can hear you, Chair.
Okay.
Okay,
Okay.
see you now.
Thank you.
Here we go.
I was saying hello to.
No, Chair, loud and clear. Proceed, Chair.
All right. Yes. I was saying hello to everybody who is participating and thanking them for the participation. I wish to also just say thank you to the two colleagues that have just spoken. My questions are to Mr. Sisoko. Thank you very much for the window that you have just opened for us into IPID. First of all, it is our wish that although we're doing slightly different things, that perhaps from time to time we should have a kind of a direct communication, because there's so many misconceptions that we get via our complainants that we can clear much quicker if we had an easier way of simply raising questions with you or making suggestions to you. But that's not the most important that I wanted to raise with you. The most important is I'm a little bit appalled that this SAPS keeps on appealing opposing, the efforts that you are making in order to get information that you need in order to do your work as the IPID. And I'm interested in knowing, should the SAPS file a petition to the Supreme Court of Appeal, perhaps could you let our CEO know so that we can decide whether, as the Commission, we would be interested in joining the litigation as amici. It is important that you do your work as best as possible, and it is important that we as the Commission promote and protect human rights, and that we should not allow activities that tend to actually hide information which may include information that relates to the violation of human rights that we are required to protect. So I think we have got an interest in that. And then secondly, you spoke about a possible amendment. Can you perhaps tell us whether there is now an amendment or it's just still proposed, so that we can be on the lookout for it and comment where possible? Thank you.
Person, I think from our side, we'll really appreciate it if the Human Rights Commission can come in as amicus. We will update you in relation to whether the matter does in fact go further, because as I've indicated, it was just the media reports that suggested that the National Commissioner was going to petition the Supreme Court of Appeal to challenge the matter. But as I understand it, he will only be challenging the part relating to the finding that he breached his obligation in terms of Section 29 of our Act, which therefore suggests that if that decision stays, it means therefore that he can be prosecuted for contravention of that Section 29 in terms of Section 33 of our Act. I think that is where his main worry is in relation to himself and two of his deputies. So, but we will update in relation to that whether the matter will if the matter still goes further than that. But for now, at least we have been able to score an important jurisprudence in the sense that there's now an obligation police to hand over documents to us, whether classified or not, in terms of our Act. And I think that is an important development in our law. In relation to the IPIT amendment bill, yes, the process has already started. It's an amendment bill already. There will be a public consultation that will happen soon. I'm not sure when. We have not been provided with the dates. As I understand now, the bill is with the state law advisors to look at it and then have it approved. Then the minister will then start processing it accordingly. I'm sure when that process happens, we'll also engage with the Human Rights Commission so that they can make their inputs into this amendment bill. I think for us, it's important. You'll remember that there was a McBride judgment which pronounced on the independence of the Constitutional Court judgment on McBride, which pronounced on the independence of IPIT. So this amendment bill is also the furtherance of that judgment, because the judgment also required Parliament to amend IPIT Act to be compliant with the Constitution. So when that process unfolds, we'll also make sure that we keep you updated so that you can make your inputs into the.
Thank you, Mr. Siseko. And of course, we look forward to engaging the draft legislation. I note a hand from Professor Cephas Lumina. If we could unmute Prof and allow him to speak, and then of course, immediately thereafter, we'll switch to the break. I don't note any other hands.
May I speak?
You may proceed, Prof. Thank you.
Okay. Thank you very much, and thank you for the kind invitation to participate in this very useful conference. I was wondering whether I should leave my comments to the end of the conference, or but then I just decided it might be useful to raise them at this particular stage. I've listened with much interest to the presentations from yesterday and this morning thus far. It seems to me, listening to the presentations, that while the conference itself is about a rights-based approach to anti-corruption, most of the presentations that thus far have focused more on the criminal justice approach, which is totally different from a rights-based approach. And I'm not quite sure that we all understand what a rights-based approach is or what a criminal justice approach is. Perhaps, I mean, the program has already been settled, but I think this is something to think about and to try and clarify. If you're going to explore and craft rights-based approaches to combating and preventing corruption. I just thought I should raise that. But I'm happy to, engage bilaterally with the Commission in writing my thoughts on these. But at the same time, I can speak further if you wish me to. But thank you.
Thank you very much, Professor Lumina. And yes, we note your comment. If I could just clarify, and I said at the outset that this is obviously just the conversation starter from our end, and we do envisage noting that this has come to as one of the priority areas for the Commission in terms of our work. That this is the beginning of the process, and then we will have a series of engagements down the line, subject, of course, to our commissioners and our performance plans and strategic plan. At the same time, you are more than welcome to send your observations or recommendations to the Commission. The nature of our work is very participatory, and we do encourage stakeholders and, of course, any interested party to please share their views with us as a view to enriching the work that we do. And so we do look forward to that. Just also note that the session after the break will zone in a bit more in terms of the human rights-based frameworks. And of course, tomorrow, towards the end of the day, there'll be further discussion in this regard. I'm about to pause for the break, but I note a hand from our colleague who is the provincial manager in the KZN office, that is Advocate Lloyd Lotz. If Lloyd could be unmuted, and then Lloyd, you have the floor for a few minutes, and thereafter we'll break till 10:30. Thank you. I think, Lloyd?
Good morning. Yes, thank you very much, Fatla. It was actually Mr. Zulu, as we're having some technical issues with the other laptop, so he's using my one. So that is why it's appearing as though it's myself that is putting my hand up, but it's Mr. Zulu. So he's right here, and he'll proceed to make his point.
Thanks very much. Good morning to everyone. There are 2 points. Am I audible enough?
You are, Mr. Zulu. You may proceed.
Thanks very much. 2 quick points. The first one is both of them are related to iPad. I would like to ask Mr. Sisogo to assist us as human rights defenders, because as we do our work to expose, fight against corruption, the other painful thing that happens is that we get victimized by the police. The police are used by powers that be to attack us in our homes, to arrest us on baseless charges. They will arrest you now and release you the next day. They will beat us up. I'm having a similar case, but I'm not going to go into details for the sake of time. But it's known. I was beaten up, I was arrested, and the matter ended up not going to court. In the presence of security companies that descended on my home at night. My family was threatened with rape and everything else. But the other matter relates to when we report matters to IPID at times. I'm having a matter that I reported in 2017, which related to a certain policeman who had a bag full of identity documents at his home. Then we sent even pictures, everything that were acquired. A firearm that had no magazine, meaning it was an illegal firearm at his home. Then instead of the iPad investigating that, they took the matter back to the police. They took it back to counterintelligence in Pietermaritzburg. And I would like to hear from the Mr. Sissoko, because those identity documents may have been used in committing corruption in as far as SASSA fraud is concerned. SASSA fraud and corruption is concerned. Thanks very much, Fatih.
Sorry, just clarity on the last question. Was the complaint against a member of the South African Police Service?
Mr. Zulu, that question is directed to you. Just a question of clarity whether the complaint was directed to SAPS or not. Lloyd and Mr. Zulu, if you could clarify.
I've answered. I said the complaint was sent to IPID. It related to an SAPS member.
Okay, thanks for the questions. I think the issue of victimization by police, it's not something that is new. We've had complaints of this nature before. So what is important is when this kind of incidents happen, it's important that they get reported to us so that we can conduct an investigation. The issue relating to the 2017 complaint that was referred back to the police, I wouldn't understand why our office would have done that. It would assist me, Mr. Zulu, if you can contact me offside, outside this platform, so that you give me more details about the specific matter. And then I can check with the office what happened to the case and why it went back to the police. If the complaint was against a member of the South African Police Service, then IPID should have investigated that matter. Only if maybe during an investigation or after the criminal investigation, they find that maybe a person involved is not a member of the police, then they would refer it back to the police for investigation, because it would fall outside of our mandate. So I'm sure colleagues at Human Rights have got my details. They can share it with you. Then you can contact me, and then we can deal with it outside this this platform. Thank you.
Thank you, Mr. Seseko, and I'm sure through our colleague Lloyd Lotz, he would be able to facilitate that engagement in sharing your contact details as promised. I do note the hand from Ms. Colette Letojani. I'm going to allow you 30 seconds just to make your intervention, and then similarly a quick response from Mr. Seseko or Mr. van Schalkwyk, depending who your question is directed to. Thereafter, we will have to break so that we can prepare for the next set of speakers. Colette, you do have the floor. Just to note, Colette, that you are muted, so if you could unmute yourself. Okay, I'm not sure if there is a technical issue on that end, but with that said, let's pause the conversation for now. It is nearly 10:30. If we can resume at 10:40, so 20 to 11, we will proceed with the discussions from the Office of the High Commissioner for Human Rights. That's the regional office in Southern Africa, and that is Mr. Jean Foucault, and followed by the CEO of the Human Rights Commission, Advocate Sadiso Tupaniani. Okay. I look forward to engaging you after the break. Okay, Colette, are you there now?
Yeah, sorry, I'm able to.
Okay, I'm going to allow you just 30 seconds. We were about to break. Okay. I think there might be a lag on your end. We were about to break, so I'm going to allow you to do your intervention, and then and for the speakers to quickly respond after we're breaking. Thank you.
Thanks, Madam, for giving me this opportunity. Thanks to the Commission and the organizers. I just wanted to make a quick intervention with the IPID and the police as well. During level 5 and 4 of the lockdown, we had two cases, one happening in the Vaal, the other one somewhere in the north of Johannesburg. Two young girls who happened to have captured police, brutality in some of the protests that were happening, and then the police caught these young girls, have them arrested, and they spent a night in prison, and the next day they were taken into court, no charge, and they were sitting there wondering why they've been brought. They were arrested and brought to court, and then they were told that their matter has been they have been discharged, and they wanted to charge police for unlawful arrest, and the police threatened them and mentioned that they're actually going to blacklist them, you know, through all sorts of threats. The second one is with a young girl who got caught because the police learned that there was some breaking into a shop, there was looting and all that. The young girl is working to buy a SIM card, and police, she's so young, they mishandled her, they abused her, threw her on the ground, brutalized her, and they took her to the police station. And then she went back home. Her parents came in to help her open up a case to charge the police. And then there were about 3 of the police, the suspects, and they refused her and her mother to open up. So it took them about 2 days before they were able to put charges against those police. And also they came to us to help them lay a charge and fill up that complaint forms to IPID. These matters have not been resolved. So, you know, people are facing all these challenges, and if IPID, you know, maybe it's overwhelmed with work, they are not attending to complaints that are taking place on the ground, you know, the impunity continues and police continue with their misconduct, and people fear to report or to come forward because nothing happens. Thank you very much for the opportunity.
Thank you very much, Colette, and your observations and concerns are well noted. I'm not sure if it's really a question or more just commentary that you've shared with the floor, but I do note it. If we may break, then it is just after 10:30, and as I say, it's just so that we can respect time and allow our next set of speakers adequate preparation and for the technical preparation on our end. So it's now 10:30. We will resume at 10:40 as indicated. So that's 20 to 11. Thank you so much. And thank you to our 2 speakers that have just presented, Mr. van Schalkwyk and Mr. Siseko. Thanks for your contribution.
Thank you.
Hello again, colleagues. I hope that everybody has rejoined us, or if you haven't left, thank you for staying. We're about to commence part 2 of today's discussions, which, as mentioned earlier, will be looking more at the international best practices towards a human rights-based approach in tackling corruption, as well as the role of national human rights institutions, or rather the perspectives of an NHRI and our work in accordance with combating corruption. I'm going to open and allow our colleague from the Office of the High Commissioner, or the High Commissioner for Human Rights in the Regional Office of Southern Africa, based in Pretoria, Monsieur Jean-Bofi Fokwa, to take the floor and give us some perspective, particularly noting that there'd been quite a lot of developments at the international level around the UN Convention Against Corruption, and then more so also even at the regional level, though we're not particularly addressing that today. But if Monsieur Fokwa, you have the floor, if you could do your presentation on behalf of OHCHR. Thank you.
Good morning, everyone. I shared my presentation, and I would very much appreciate if it could be projected, please.
Mr. Fokwa, that is noted. We are just waiting for a colleague to upload it. Thank you.
Okay, thank you so much. I'm going to turn on my video for now because of the connection. I hope that is okay, because there seemed to be a problem with the connection. So I'll turn off my video for now, but at some point I'll turn it back on. All right, thank you so much. My presentation is going to focus on integrating human rights into national strategies and policies to fight against corruption. And the presentation is also going to touch on some good practices and standards. Next slide, please. My presentation is going to have 5 components, and some of them have already been looked at by previous speakers. But we are going to just look at the definition of corruption. We are going to look at the international legal framework to address corruption. We are also going to look at the impact of corruption on human rights briefly. And then we are also going to dive into human rights-based approach to address corruption. And then the last segment of the presentation is going to look at some good practices applied by states to integrate human rights to fight against corruption. Next slide, please. I think, as was mentioned by previous speakers, there is no internationally agreed legal definition in relation to corruption. And the most widely used definition is the one that has been put forward by Transparency International, that defines corruption as the abuse of entrusted power for private gain. Next slide, please. In terms of the international legal framework to address corruption, I think we have touched on it before. Here I am referring to the United Nations Convention Against Corruption. Sorry, I didn't change that. And then you have which South Africa adopted. South Africa ratified on the 2nd of November 2004. Next slide, please. In terms of acts of corruption, I think some of the acts of corruption have been highlighted in the Convention Against Corruption, and this list is not an exhaustive list. Here you have bribery, you have trading in influence, you have abuse of functions, you have embezzlement, and you have illicit enrichment. And I just want to mention that this list is not exhaustive because depending on the national context, other offenses can also qualify as an act of corruption. Next slide, please. In terms of the United Nations Convention Against corruption. It is a comprehensive international instrument that is aimed at combating the scourge of corruption around the world. And it places an obligation on state parties to take necessary steps in order to criminalize corrupt acts, and also to ensure that effective laws are put in place in cooperation with other state parties in order to address corruption. Next slide, please. I think if we look at Article 5 of the convention, it has some key points that places obligation on state party. State parties are supposed to develop and implement or maintain effective coordinated anti-corruption policies, establish and promote effective practices aimed at the prevention of corruption. State parties are also supposed to periodically evaluate relevant legal instruments and administrative measures with the view of determining their adequacy to prevent and fight against corruption. Next slide, please. I think this point has also been touched on by previous speakers, and I am just going to highlight on this, that corruption has a very huge impact on human rights. And here we are referring to economic, social, and cultural rights, such as right to work, right to food, the right to housing, the right to health, the right to education, the right to public services, the right to development as well. And this is especially when public funds and services do not get to the beneficiaries, and if they are not well managed. It also has an impact on the principle of non-discrimination, and corruption also impacts on civil and political rights, such as the right to fair trial and the right to public participation. And we are going to elaborate more on this in the course of this presentation. The crux of this presentation is to look at how do states integrate human rights-based approach into addressing corruption. I think our entry point here is to look at what do we mean by human rights-based approach, and I think this is a point that was put forward by one of the participants. I think human rights-based approach, it defines a human rights-based approach to anti-corruption as an approach which puts the international human rights entitlements and claims of the people. Here we are referring to the right holders and the corresponding obligation of the state, which is the duty bearer, in the center of anti-corruption efforts. And it is an approach which integrates human rights principles, including non-discrimination and equality, participation and inclusion, accountability, transparency, and the rule of law in all the efforts that are being put in place to address corruption. In terms of the standards and principles that we are supposed to rely on to inform human rights-based approach are international human rights treaties, which a country is a state party to. In the context of South Africa, South Africa is a state party to 7 of the core 9 human rights treaties. We also have to look at the treaties and the conventions, and we also have to look at general comments from the treaty monitoring bodies that are responsible to monitor implementation of the treaties. In terms of the good practices that we are going to look at in this report, I would like to just highlight to you that the good practices in this report are informed by a report that was prepared by the Office of the High Commissioner for Human Rights after the office was requested by the Human Rights Council to prepare a report on challenges faced and best practices applied by state in integrating human rights into the national strategies and policies. And the report was prepared based on Human Rights Council Resolution 41/9, and the report was prepared. It was presented to the Human Rights Council in April 2020. And I just want to also highlight that input to prepare this report was received from so many stakeholders, from states, from international and regional organizations, from national human rights institutions, and from civil society organizations. And I've also added a link where you can access to have a copy of this report. Next slide, please. I think the first point that we have to look at, which is very vital in order to integrate human rights standards to fight against corruption, is to ensure that any strategy, any policy that is aimed at fighting corruption should be anchored along the standards of human rights, and it should also be very inclusive. This is simply because an efficient anti-corruption strategy must be informed by key human rights principles. And I also just want to mention that it is very important that these human rights, these anti-corruption strategies should not be developed in isolation. It is very important for these strategies to be incorporated within a broader national development initiatives, such as national development plans. But it is very important for these strategies to be informed by key human rights principles. Another point that it is also very important is that, which is in line with the principle of participation, is the fact that when developing a strategy to fight against corruption, there is a need for the strategy to be developed mindful of the need to include other stakeholders. And there must be a very broad-based consultation process to involve various stakeholders in the development of the strategy. In terms of some of the standards and that we have to look at, we are looking at issues in relation to good governance, the rule of law, the right to information, the right to take part in the conduct of public affairs, the right to a fair trial, the creation of a safe environment for anti-corruption activities and whistleblowing. We are going to elaborate more on this. Independent media, independent and impartial judiciary. So these are some of the key principles and key standards that need to be taken into consideration when developing a strategy to fight corruption. Next slide, please. The next point that we have to look at is that if we really have to integrate human rights-based approach to fight against corruption, if you look at Article 6 of the Convention Against Corruption, it talks about the need for states to ensure that there exists a body that is responsible for leading initiatives to fight against corruption. But the Human Rights Council in its resolution 41.9 has actually elaborated that it is very important to encourage some sort of collaboration and consultation between a national human rights institution and other bodies that are responsible for fighting corruption. And this is a point that was actually made as well by the chair of the commission, that there is a need for a national human rights institution to also be able to work in close collaboration with other national entities that are aimed at fighting corruption. And an example here, if you look through the report, you're going to see an example from Austria, where you have the Austria Federal Bureau of Anti-Corruption. This body actually works closely with the National Human Rights Commission of Austria, and all the initiatives of the Austria Federal Bureau of Anti-Corruption takes into consideration human rights-based approach. And other countries have cited weak linkage between national human rights institution and anti-corruption body as an impediment to integrating human rights to fight against corruption. So I think this is a very good point that we need to also take into consideration. Next slide, please. The rule of law. I think as we all know, it is very, very important that when we fight against corruption, it is very, very important for us to integrate issues in relation to adhering to the rule of law. And state parties should apply codes and standards of conduct for correct, honorable, and proper performance of public functions. And I just want to highlight here that it doesn't suffice to simply have these codes or standards of conduct for correct, honorable, and proper performance of public functions. But it is very, very important for state parties to ensure that measures are put in place to implement these codes or standards, and also to discipline public officials that contravene the code or standards that they are supposed to adhere to. And also in relation to this, states should establish measures and systems requiring public officials to make declarations regarding their outside activities, employment, investments, assets, and substantial gifts or benefits from which a conflict of interest may result. So this is very important. The next point that we also have to look at in terms of the rule of law is the fact that it is very, very important for states to ensure that there is an impartial and independent judiciary, simply because the integrity of the judiciary and prosecution services are very important elements to take into consideration when we talk about fair trial and the need to combat corruption. Another point that we also have to look at, please, if we may just go back to the last slide, please. The previous slide, please. I think one other point that we also have to look at is to ensure that the integrity of the justice system is maintained. And here we had some good examples. For example, a country such as Mauritius also highlighted that codes or standards are existing to ensure that public officials do not get themselves into corrupt acts. Next slide, please. The next point that is very, very important for us to look at is transparency and accountability in public procurement and management of public services. This is a point that has also been articulated in Article 9 of the Convention Against Torture, and it has Convention Against Corruption. It highlights the importance of transparency and accountability in public procurement and the management of public finances. I think this is a very key point that we really need to take into consideration. And then if you also want to link this as well to budget, I think this principle has also been highlighted by human rights mechanisms as well. If you have seen recommendations from human rights mechanisms, such as the Committee on the Right of the Child, the Committee on Economic, Social, and Cultural Rights, the Committee on the Rights of Persons with Disabilities, they have actually articulated that when there is no transparency, when there is no accountability in public budget, it impacts on the protection of the rights of children. It also impacts on the rights of persons with disabilities, and it also impacts on the ability of the state to be able to realize its obligation under the Covenant on Economic, Social, and Cultural Rights. The next point that we also have to look at is the fact that transparency contributes to efficiency and combats corruption and mismanagement of public budget, and it is a prerequisite for enabling meaningful participation. As was mentioned by one of the participants on the role of civil society, I think it is very, very important if we want other stakeholders like civil society organizations to participate in efforts to combat corruption. There's a need for transparency in order to share information, which is also going to lead to meaningful participation. Next slide, please.
Mr. Foko, I'm so sorry to interrupt. You have 2 minutes left.
All right, 2 more minutes.
Thank you.
Yes.
Yeah.
Thank you so much. And then I also just want to touch on freedom of information and fight against corruption. I think freedom of information is also linked to transparency. And I think this is a point that has also been articulated by Article 13 sub 1 of the Convention Against Torture, that there's a need to ensure that there's right to freedom of information to fight against torture. Next slide, please. To fight against corruption. Next slide, please. The next point that we also have to look at is that once there is access to information, it is also going to enable other stakeholders like civil society organizations to play a very vital role to combat corruption, as was mentioned by one of the speakers, that civil societies also have a very key role to play. Next slide, please. Next slide, please. The next point I just want to mention is addressing corruption in the private sector. I think one other point that we also have to look at in order to ensure that human rights is integrated in the fight against corruption is to also be guided by the guiding principles on business and human rights that provides internationally accepted standards for preventing and addressing the risk of adverse impacts of human rights linked to business activities, and actions of multinational corporations, national corporations as well, can also have a corruption dimension, and it is also an obligation on the state to address these issues in the private sector as well. Next slide, please. I'll just move to the next slide due to time. I think I've already touched on this. Next slide, please. This is a very key point that is very important to also look at, is that when a state is putting in place criminal measures and also to enforce laws, it is very, very important to ensure that these measures should be in line with human rights-based approach. And I think if you also want to look at penalties as well, it is very important for states to try to abolish the death penalty for corruption offenses, or at least impose a moratorium on sentences in relation to corruption. Next slide, please. It is also very, very important to ensure that offenses in relation to corruption should be prosecuted. I think there's a need for states to strike a balance between privileges of national officials and also the need to ensure that there is prosecution of corrupt offenses as well. And then the next point I just want to touch on to conclude is a point that was also mentioned by one of the speakers, that when civil society actors, when whistleblowers, when they share information in relation to corruption. They are victims of reprisals. They are being threatened. I think it is very, very important for the state to put in place protection measures to ensure that whistleblowers are protected when they provide information in relation to corruption as well. Next slide. And then to conclude, it is also important that in terms of international cooperation, there should be the need to integrate human rights-based approach. I think there's a need for human rights to be safeguarded during cases of extradition and also mutual legal assistance requests. This is very, very important. I think I'm going to end here due to time, and if there are questions, I will not hesitate to take the questions at the when the questions are put forward. Thank you so much.
Thank you so much, Monsieur Jean Foucault from the Office of the High Commissioner for Human Rights for the very comprehensive presentation. If I can add, noting that we were unable to secure the participation of someone from the African Commission, but if I can add my penny to the plate, just so that it's not an obvious omission, to note that within the African regional mechanisms, there is the African Union Convention on the Prevention and Combating of Corruption, and that was adopted in July 2003. Similarly, as with the UN Convention, whilst they don't necessarily define what corruption is, it does list the acts and practices which can be regarded as corruption. And I think they're quite expansive under Article 4 of that convention. At the same time, there's the African Union Advisory Board on Corruption. And as recent as, I think, November last year, so they released quite a concerning statement noting that there had been a number of reports around the increases of corruption on the continent, particularly within the COVID-19 pandemic. So it wasn't a unique phenomenon to South Africa only. It was being seen throughout the continent, and I assume the world as well. But more so within the African continent, we found that there were persons profiteering off PPE, ventilators, equipment that should have been directed to hospitals. And we found that the African Commission had released a statement together with the Advisory Board on Corruption, expressing their concern and condemnation around these sort of acts and how it actually takes away from human rights and the service delivery. I am going to, I see our CEO is ready. So I'm going to, before we hand over, just to set the context, the CEO will be giving some input and perspectives on the National Human Rights Institutions, perspectives on anti-corruption and the human rights-based approach there too. So the South African Human Rights Commission is an A status NHRI, which means that we have the highest rank in terms of the international community of NHRIs. We are part of the Global Alliance of National Human Rights Institutions, as well as the Network of African National Human Rights Institutions, that's NANRI. And on that, I do want to note the presence of the Executive Director of NANRI, who is also in attendance today, and that's Monsieur Gilbert Sebioho. Thank you for joining us as well. I will hand over the floor to our CEO, Advocate Tipanyani, to give some insights on the NHRI perspective on this issue. Thank you. Chief, you have the floor.
Thank you, Fadla, and ladies and gentlemen and colleagues. It's a pleasure again for us to be here with you just to reflect on some of these issues from our perspective as a national human rights institution, and also from a human rights approach perspective. I also want to thank our colleagues from the Office of the UN High Commissioner for Human Rights for laying down a very important approach, a human rights approach to issues of corruption. Now, it's very clear, colleagues, that it is no longer a debate that corruption in all its forms and manifestation has a major impact on human rights. And in this regard, I would like to refer to a quote by Justice Mosaneke and Cameroon in the judgment of Tlenista versus President of the Republic of South Africa and others. It's a 2011 case by the Constitutional Court. And this, if I may be allowed, they say there can be no gainsaying that corruption threatens to fell at the knees virtually everything we hold dear and precious in our hard-won constitutional democracy. It blatantly undermines the democratic ethos, the institutions of democracy, rule of law, and the foundational values of our nascent constitutional project. It fuels maladministration and public fraudulence and imperils the capacity of the state to fulfill its obligations to respect, protect, promote, and fulfill all the rights in the Bill of Rights. When corruption and organized crime flourish, sustainable development and economic growth are stunted. And in turn, the stability and security of society is put at risk. So that is matching orders from the Constitutional Court as far as the impact of human rights corruption has. And therefore, for us who are involved in human rights issues, in the struggle for human rights, clearly then our work should also extend to the issues of corruption. So in this regard, it is quite clear that national human rights institutions like ourselves, established under our own laws, but also established under the UN General Assembly Resolution 48/134 of 20 December 1993, commonly known as the Paris Principles, clearly gives an obligation as a national human rights institutions to respond to the challenges and threats of corruption and its impact on human rights, and do so, of course, in the context of our respective mandates as national human rights institutions. Now, it's very clear, therefore, that national human rights institutions can bring a very important human rights dimension in this very crucial struggle in the prevention and combating of torture, which is normally emphasized, with the role of your traditional anti-corruption agencies. And therefore, it's quite important in that, there must be a fusion of human rights in our anti-corruption strategies. And therefore, in this regard, national human rights institutions does bring a very important role. And then this therefore takes us to the whole discussion and discourse going forward of a human rights-based approach to anti-corruption and I think the colleague from the Office of the High Commissioner has highlighted what this means. And therefore, I will just briefly explain this in a summarized manner what is deemed to be a human rights-based approach to the prevention and combating of corruption. And of course, I borrow quite extensively from the work done by the Office of the High Commissioner for Human Rights itself on this matter. But in essence, this approach basically identifies corruption as a human rights issue and not just a crime or an economic factor. And therefore, it promotes a much more integrated approach in how we address corruption. It also calls upon an active involvement of civil society in fighting corruption. So basically, corruption, the fight against corruption then is a matter which concerns all of us, not just your traditional anti-corruption agencies like the police, NPA in our country, the prosecution services, and so forth. But it's really a much more holistic approach, and therefore an approach which is clearly much more advantageous and more sustainable in the fight against corruption. Because corruption is not a new thing, colleagues, has been here all this time. But in our country and many other countries, we see increase in corruption, and which therefore raise the question, are we following wrong strategies, or is there a problem with those strategies? And I think it's quite clear that we have been quite weak as far as infusing human rights-based approaches in our anti-corruption strategies. Also have been quite weak in an inadequate contribution and role of national human rights institutions in fighting corruption in our country. We have just turned 25 years as a Human Rights Commission, and therefore we can reflect back over the past 25 years, to what extent have we as a commission been involved in the fight against corruption in view of its extensive and damaging impact on human rights. And hence this conference and hence also the initiative we've taken to actually focus a little bit more. So it's very clear that if we had also done a bit more as a commission 25 years earlier, definitely we might be talking about different things. But as I say, better late than ever. So here we are now, and of course, this new discourse, emerging discourse, that national human rights institutions should be involved in the fight against corruption from a human rights-based approach. Now, there are a number of benefits of a human rights-based approach, which I will outline, not all of them in the interest of time, but certainly one of them is very clear, that it helps to break the silos between your traditional anti-corruption agencies as currently understood and human rights defenders. Because for quite some time, the work on corruption has been seen as, has been seen from a perspective of a criminal law agencies and less of a human rights issues. And therefore, many human rights defenders and human rights activists and national human rights institutions have not adequately got into the fray of basically fighting this. So a human rights-based approach helps to break down the silos and therefore encourage greater interaction between all the agencies which are committed to fighting crime. Secondly, it provides a much more effective and sustainable anti-corruption strategy in the sense that it also requires us to take into account all human rights standards and principles, which means those police officers who are not corrupt, who are fighting crime and corruption, will be more effective, of course, if they were also informed by human rights standards and in principles. Thirdly, a human rights-based approach, as has been mentioned elsewhere, it puts the victim at the center to anti-corruption strategies. The victim who is a victim of human rights violation as a result of corruption is at the center. It also then helps to empower the victims of corruption to get more involved, because now it's very clear that corruption affects their rights, access to safe drinking water, access to primary education, and so forth. So this means that, if there was a greater appreciation of the devastating impact of corruption on the normal enjoyment of human rights like water, housing, and education, and so forth, it will therefore help to mobilize more people to actually join hands in the fight against corruption in our country. And therefore, it also, another benefit, it helps to make the realization of human rights as an anti-corruption goal, not just fighting corruption, but actually seeing the fight against corruption as a fight towards realizing human rights. And therefore, this will then change the mindset in many of us. But the other benefit is that it also helps in addressing the structural cause of corruption, and not just dealing with the symptoms, but what informs corruption. How then do we deal with this? So those who are in the human rights movement will understand that we do need to prevent the violation of human rights. And therefore, we don't just look at corruption from its manifestation, but also what informs it and how can we then work better to ensure that we are more successful. And lastly, of course, a human rights-based approach creates a platform for national human rights institutions to get more involved in the fight against corruption. So this approach of a human rights-based approach to corruption, colleagues, is a very important development in the discourse of human rights, and therefore we all need to get more involved as national human rights institutions, as human rights defenders, and of course work much more closer with your traditional anti-corruption agencies. Now, in conclusion, I just want to highlight, the role then of the Human Rights Commission in this regard, as far as fighting corruption, in this regard. Now, as you can see, in terms of our act, the Human Rights Commission has got a tremendous amount of of powers and mandate to us to contribute in the fight against Human Rights Commission. So if you look at Section 13 of our Act, there are a lot of powers or activities which the Human Rights Commission can engage with in the fight against corruption. And I'll just go very quickly through some of them. First one is that the Commission has a mandate to make recommendations to government on human rights issues. And therefore, where corruption impacts human rights, the Commission has a mandate to make recommendations as to how best we can deal with corruption activities and strategies in order to, to be much more successful in this fight. Two, we have a mandate to undertake studies. So these studies can also include how corruption affects human rights. And number three, we have the powers to request information from any organ of state on measures which have been taken by the state or organs of state to address issues of corruption. And therefore, we then make further recommendations on that. And number four is to develop and conduct and manage information programs and education. Clearly, one of the biggest tools in our country of fighting corruption is really to raise greater awareness amongst our people that corruption does undermine human rights, and all of us have to get more involved. So a national human rights institution like ourselves can play that role in raising greater awareness amongst our people and mobilize our people to basically join hands in fighting corruption, which is becoming quite clearly a major threat to human rights. And some people are saying already that it should be regarded as really constituting a crime against humanity. And therefore, it requires a much more greater input around that. Then, of course, there's also a requirement under Section 13 for us to maintain a close liaison with institutions with similar objectives to the Commission, which means then we are obliged and required to work much more closer with the anti-corruption agencies, which are already here before us. And therefore, that's another challenge for us as the Human Rights Commission. But more importantly, also, we are required to liaise and interact with organizations which are also actively involved in the protection and promotion of human rights, which means we also have to forge new partnership with organs of civil society, which are also engaged in the fight against corruption from a human rights perspective. So our own act already gives us this framework in this regard. And then lastly, or second last, is that we have a mandate also under our act to monitor and assess how government discharges its international obligations or treaty obligations and report to Parliament on that. Now, Fadla was already mentioned that we have ratified two conventions, the UN Convention on Corruption and the African Union Convention on Preventing and Combating Corruption. Now, clearly, we as the Human Rights Commission can do a bit more in terms of monitoring how our own government, gives effect to this treaties it has ratified. Now, if you look, for example, at the UN Convention, Article 13 of the UN Convention on Corruption requires the state to promote the active participation of individuals and groups outside the public sector in order to help to combat, to prevent and fight against corruption. So we should then be assessing to what extent has our own government given effect to Article 13 in order to encourage participation of civil society in fighting corruption. And therefore, we should also be telling Parliament this is not being done well and we could do better. The same thing also applies to the EU Convention on Preventing and Combating Corruption. Article 12 also talks about the role of civil society and media, that government must be fully engaged with all these entities in order to contribute towards the fight against corruption, but also to ensure that there's greater levels of transparency and accountability. And therefore, again, we need to ask exactly what are we doing as a government to give effect to these two instruments, which we have ratified as a country and also as a commission. So in those regards, commission colleagues, there's clearly a lot which could be done by us as the commission, as well as Chapter 9 institutions. And I would like, in closing, to acknowledge the role which the public protector has played in its report, which has now led to the Zondo Commission, because this is definitely a game changer in our country. Our people are beginning to realize the extent of corruption in our country and its impact, and therefore the need for all of us to stand up and join hands and fight against this. And therefore, a human rights approach based will definitely make a major contribution. And secondly, the greater involvement and participation of national human rights institutions like ourselves, in partnership with organs of society, the media, and everybody else, will definitely take us a long way in ensuring that we do defeat the scourge of corruption in our country, which affects mostly the poor, the marginalized, and the children. Thank you.
Thank you so much, CEO. Just if I also may add to it, is to also underscore not only the role of NHRIs in the domestic sense and internationally, but also the role that we could play at the SDG level. So particularly under Goal 16, and if I'm not mistaken, it's 16.5, which requests that, or specifically states that states are to substantially reduce corruption and bribery in all their forms by 2030. Now, of course, that is a bit ambitious, noting that 2030 is around the corner and the setbacks that we've had around COVID-19. But at the international level, we have noticed through the SDG engagements that corruption does have a disastrous impact on human rights. And under that very same goal, Goal 16, there's a recognition of the role of relevant national human rights institutions and other stakeholders in calling out and building capacity around all levels regarding not just corruption, but the Sustainable Development Goals as a whole. I would also encourage the viewers and those that are present to engage these international and regional mechanisms, because they do allow for active citizenry, for participants to give their views and their information. So when we do appear before treaty bodies around these supranational structures, you are permitted to submit parallel reports and give your insight into the realization of a particular right and how South Africa has fared in giving effect to their international and regional human rights obligations. As the Human Rights Commission, we are quite active in that space as well in submitting independent NHRI reports to these structures. And of course, it's open to the public as well to do the same. I am going to open the floor for questions. And I do note that it gets a bit tricky at this point with the technical glitches. So I don't see any hands just yet. So I'm going to give it a few seconds and hope that we'd be able to see a few hands pop up. And then, of course, it would be directed to our two speakers within the context of their presentations. Professor Lumina, I note you. I will give you the floor. Thank you. If IT could kindly unmute Prof. Lumina. Thanks.
Can you hear me?
We can. You may proceed, Professor.
Okay, thank you very much. Very briefly, I want to thank Mr. Fokwa and Advocate Shipanyane for their very insightful presentations, addresses to a large extent the comments that I made concerning clarity on a rights-based approach. And I just wanted to add a few things, and I do so as a former member of the United Nations Committee on the Rights of the Child. When I was on the committee, I was a focal point on corruption and children's rights. And in that capacity, I also actively coordinated a joint statement of the UN treaty bodies on corruption and human rights, which basically reflects the reality that all the UN treaty bodies recognize corruption as a challenge to the enjoyment and realization of human rights. But speaking specifically about the CRRC, most of our recommendations in the concluding observations were reflective of Article 9 of the UN Convention Against Corruption. And so our focus was largely on the link between corruption and the lack of transparency in public financial management, and also the link between corruption and the state's obligation to utilize resources efficiently for the realization of children's rights. Many of our recommendations also focused on public procurement, and I think this is a huge issue for South Africa if one looks at recent allegations of inflated public procurement contracts in relation or in the context of the COVID pandemic. So I'm very, very pleased that the Human Rights Commission has decided to, take a more active role in relation to this issue. Just on the elements of a human rights-based approach, I just wanted to add that this approach focuses on, amongst others, three things. One, the question of reparations for victims of corruption. Secondly, the need for compliance with human rights standards in the course of investigations and prosecution of those accused of corruption, including in the context of asset forfeiture. It's important, that fair trial guarantees and all relevant, human rights guarantees are adhered to. And finally, this is an issue that was raised, I think, by Mr. Zulu, the issue of protecting those that report corruption. But beyond that, also those that investigate and prosecute corruption. Often there are risks to their personal integrity that we need to take into account of. But having said that, I just want to ask both Advocate Shipanyan and Mr. Fokwa if they can elaborate a little bit more where they see the complementarities between a rights-based approach and a criminal justice approach. Thank you.
Thank you, Professor. I'm just checking if there are any other hands, because I know the nature of virtual participation is obviously that inputs come in a little bit later once the conversation gets going. I don't see any hands at this point, but I will then allow the CEO and Mr. Fokwa to respond to Professor Lumina. Can I get an indication of who prefers to go first? Okay. Before I don't see any response there. Okay, Chief Professor, or rather CEO, you have the floor. And then thereafter, Monsieur Fokwa, and I will give the floor to Mr. Hanif Ali, who is lined up for a question.
Thank you for the question. Yeah, I'm just looking at the quote here from the Office of the High Commissioner. It says tackling corruption should be seen as tackling obstacles to human rights, as well as a specific violation of human rights. So the criminal justice system is really there also to promote and protect human rights, even though from a criminal law point of view. And then the human rights-based approach, it's to say, let us look at the broader human rights issues. And therefore, that's why then there's a call that there must be a synergy between the two components. I mean, I sometimes refer to police officers as human rights officers number one. So they are focusing on human rights issues, even though maybe from a narrow point of view. Whereas a human rights-based approach then also address the broader issues like the impact on socioeconomic rights, impact on housing and water and environment. And therefore, they should really be a greater synergy between the two. We are quite aware, of course, traditionally, the focus has always been on the criminal justice part. The weaknesses there was that, we're not really putting the victim as a center, nor are we putting the achievement of human rights as a goal. partly because of traditions, and hence the new approach to say, listen, corruption affects human rights, and therefore we need a human rights-based approach, which means those who are in the traditional criminal justice system agencies also have to have a little bit of orientation to see this from a human rights point lenses than before. Thanks.
Hello.
Hi, Mr. Farquhar, you might proceed.
Yes, thanks. I just want to add on what the CEO mentioned. I think if we look at the question, it is right to say that the criminal justice system and the human rights-based approach do complement each other, as was mentioned by the CEO. Because if you look at, for example, Article 30 sub 1 of the Convention Against Torture, although it stipulates that state parties should make the commission of corruption offenses liable to sanctions that take into account the gravity of the offense, it also proceeds in terms of Article 65 sub 2 to also state that the convention should also take into account the need to ensure that sanctions should not affect the right to life and the prohibition of torture and other cruel, inhumane, or degrading treatment. And as the CEO mentioned, I think it is also very important for the criminal justice system to also take into consideration the right of the victim as well, but also to take into consideration the rights of the aggrieved parties. So I think they complement each other, and that is why it is so important that when looking at issues in relation to corruption, it is very, very important to integrate human rights standards and human rights principles in all the efforts. Thanks.
Thank you, Mr. Farquhar. I am not sure. I think Prof. Lumina, I don't know if that's an old hand that you haven't dropped as yet, but I note that we had Mr. Vali's hand up earlier. I've seen it since dropped. I'm not sure if that was an error on his end. Okay, Mr. Vali, I note you again. IT could kindly unmute Mr. Hanif Vali to give him the floor. Thank you.
Thanks, Ms. Adams. My question relates to what proactive steps can the Human Rights Commission take? We have a situation where we have serious problems with governance in this country because there's corruption across the board. Proactively, with the Human Rights Commission playing the role of protecting the citizens of this country, can they, for example, using the principle of illicit enrichment, request people who are in positions of authority, who should have delivered on very basic services, to account for illicit enrichment, which is one of the provisions in the Convention Against Corruption? That's my one question. Number two, I want to ask of Rosa, Mr. Farquhar, if they have at all interacted with government in terms of the government's obligations, in terms of the International Convention Against Corruption, which the government has in fact signed. Regarding issues such as illicit enrichment, one of the issues we have in this country is the lack of prosecutions. And one of the reasons for the lack of prosecutions is the need to prove a case beyond reasonable doubt. So when you use the issue of illicit enrichment, then the issue of the onus is in fact shifted in the sense that on a balance of probability, a person who has got unexplained wealth needs to justify how they got this unexplained wealth. So how has the UN interacted with government on this issue, and what steps has the Human Rights Commission taken proactively to address the issue of corruption? Thank you, Madam.
Thank you, Mr. Vali. CEO, I'll give you the floor to respond to the last part of that question, and then the one around reporting will be directed to Mr. Farquhar. Thanks.
Thank you. If we see corruption as an obstacle to human rights, as well as constituting specific violations of human rights, the Human Rights Commission, in terms of Section 184, has a mandate to find appropriate redress where human rights have been violated. So it's definitely something which we as a commission have to reflect a little bit more to see how best can we engage with these issues. I just need to inform colleagues, and I think the chair did mention this, that we have taken it upon ourselves to include the issue of corruption, good governance, and human rights as one of our key strategic objectives for the next few coming years. And therefore, we as the commission also have to, come up with new plans and ideas as to how we can basically, make progress in this area. So clearly, from our mandate, once it's as a human rights violation, then we can find an appropriate redress, and appropriate redress can be anything. But secondly, it also means that, when we deal with human rights violations going forward as a commission, we have to keep an eye on the connection between corruption and human rights violations in a broader sense, and then be able to tackle that. And in this way, then we'll also be contributing as a Human Rights Commission in the fight against corruption. Thirdly, we are looking at the Protected Disclosures Amendment Act of 2017, where we're also mentioned as a commission, as a node for protected disclosure. And therefore, what should we do as a commission to protect the whistleblowers, to protect human rights defenders? In this way, then, if there is a greater protection, then definitely there will be more people committed and coming out, to raise issues of corruption, and therefore do make a contribution in this regard. And therefore, we're also looking to see, whether the existing legal framework which protects whistleblowers and human rights defenders is adequate or not. And if not, then we'll engage with the state, and if needs be, we'll have to go to court. So these are some of the issues which we'll have to look into. And of course, as we monitor the observance of human rights as mandated and report to various UN human rights treaty bodies as well as regional bodies, again, we do need to look into this. And as I was saying earlier on, we definitely have to start focusing also on the extent to which government is giving effect to the two international and regional conventions on corruption. We've really not been doing a lot of work in this regard. But fourthly, as we were saying, we also have to engage with the other anti-corruption agencies. And I think this conference is really a start for us, where we are engaging with various state entities, public protector, AG, IPID, and everybody else, to see how best we can work together to get rid of this scourge from our country. So yes, as I was saying, better late than never. We could have done much better earlier on, but here we are, and we're definitely committed as a commission to make a massive contribution in the fight against corruption, and work with civil society as well to ensure that we do succeed, because it's very clear to us that corruption is a violation of human rights, and we have a mandate as a commission to respond to human rights violations in all their manifestations and forms. Thank you.
Hello.
Hi, Mr. Farquhar, you may proceed.
Yes, thank you so much for the question. In terms of engaging with the government on issues in the relation to corruption, we have been engaging with the government and other stakeholders on broader human rights issues that may also be impacted by corruption as well. We have been engaging with the government to ensure that when the government is submitting its state report to treaty bodies, mindful of the fact that South Africa is a state party to 7 of the 9 core human rights treaties. We try to engage with the government to ensure that issues and concerns that relate to the inability of the government to realize some of the rights articulated in the human rights treaties. If these issues are linked to corruption, we try to advise the government to ensure that these issues should be reflected in the state report in order to ensure that the state can also receive some recommendations as well on how to implement some of those recommendations. We also work with civil society organizations, mindful of the fact that civil society organizations also submit a shadow report to the various treaty bodies and also to the Universal Periodic Review, which is also a mechanism under the Human Rights Council. We try to also engage with civil society organizations as well to also ensure that they provide information to these mechanisms in order to make the expert members of these committees to have information that indicates that some of these rights are not being implemented as a result of acts of corruption, so that the government can receive recommendations in order to try to implement some of those recommendations. So in terms of working with the government specifically on corruption, we have really not been doing that, but we also work closely with the National Human Rights Commission, that we also engage and also put forward some of our ideas and concerns through the National Human Rights Commission. Thanks.
Thank you, Mr. Fokwa. I don't see any other hands, but I think we have come to the end of today's proceedings. Let me just double check before we close. Yeah, definitely no hands. But as I said, and as the CEO has mentioned, this is an ongoing discussion. So this is the starter. We're yet to go fully into this topic. And of course, we envisage that down the line, there will be a lot more nuanced perspectives around particular sub-themes relating to corruption and human rights particularly. I want to, at this point, thank our speakers for today, and that was the IPID, the Auditor General, IPID earlier this morning, the Auditor General's Office, Office of the High Commissioner for Human Rights, and then of course our CEO, who have all given very enriching contributions in terms of the discussions and looking at human rights within the context of anti-corruption and combating corruption. A few takeaways for today specifically, and for this I'm going to remind our viewers to please engage the Auditor General's report when it is released tomorrow. That's the general report as was mentioned by Mr. Van Skalk, to look at the findings and the analysis in light of the PFMA. At the same time, we do look forward to the draft legislation in respect of amending IPID. I know that the wheels of justice sometimes turn slowly, and so they do at the parliamentary level as well in terms of the legislative wheels. We're hoping that that will be expedited to address the shortcomings in the current existing act of IPID. In terms of tomorrow's proceedings, just to note that it is the last day of this conference, and we'll be looking at matters a lot more on a technical basis around the current anti-corruption mechanisms towards the future of anti-corruption in South Africa, and what collectively should be done by all interested stakeholders. So we have on the agenda tomorrow, we have Corruption Watch, we have a representative from the South Coast Business Chamber, that's Dr. Peter Munns. Corruption Watch will be represented by Dr. David Lewis. We have Office of the Public Protector, again, tomorrow, as well as tentatively the department. I think what many, and we have been receiving some private chats on the side with participants who perhaps are not comfortable in addressing the platform openly. We do note those comments, thank you. But I would encourage you, particularly tomorrow in the second session, to tune in and listen, or rather engage around the talks around developing a possible machinery or mechanism spearheaded by the Commission, looking at initiatives around a national alliance, perhaps around anti-corruption, or possibly through our enabling legislation, how that can be done. I don't want to preempt tomorrow's conversation, but I do think that that is something that we would definitely wish to have as many voices as possible, noting that there is this position on the table that there will be the establishment of a National Anti-Corruption Advisory Council, and that's being fast-tracked. And to what extent actually is that council going to be representative of the people of South Africa, and of course the human rights voices that should be around that table when that council is established or when their mandate is set out. So perhaps tomorrow is the ideal time to also explore all those issues. I am going to wrap it up at this point. I'm not sure if there's any closing comments from our CEO or our chairperson at this point. In terms of protocol, I will give them a few seconds if they wish to add anything in closure. Chief and Chair. Okay, I think thumbs up from the CEO, so it's all good on his side. And I'm not sure, Chairperson, if there's anything you wish to add at this point. Otherwise, we will resume tomorrow. And again, please do follow on our social media pages and our YouTube link. And for participants and attendees that have RSVP'd, you will receive the link as well. On that note, from my end, thank you very much for joining us. Have a beautiful afternoon further. Thank you so much. Goodbye.